Good evening, everyone. I'm attorney Angelo Abunero. Thank you for inviting me here tonight. My topic is all about the chapter 4, rights of the data subject. So first, let us know what is data subject. People whose personal information are collected, stored, and processed are called data subjects. Under Republic Act 10173, they are accorded certain rights which they may invoke and enforce against personal information controllers or processors, and which latter are duty bound to observe and respect. In the event that a data subject feels that their personal information has been misused, maliciously disclosed, or improperly disposed, or that any of the rights discussed in this topic have been violated, the data subject has a right to file a complaint with the National Privacy Commission. So Section 16 rights of the data subject. First, we have the right to be informed. Be informed whether personal information pertaining to him or her shall be, are being, or have been processed. So right to inform means that the data subject has the right to be informed when his or her personal data shall be or are being processed or have been processed. It is the most basic right as it empowers us as a data subject to consider other actions to protect our data privacy and assert our other privacy rights. B. Furnish the information indicated hereunder before the entry of his or her personal information into the processing system of the personal information controller or at the next practical opportunity. So the data subject should be notified and furnished with the following information before the entry of his or her personal data into the processing system. So collection and processing of data without the data subject's knowledge and explicit consent is made unlawful, and entities in possession of personal data is obligated to inform the data subject of any breaches or compromises in their data. Next is the right to object. The data subject has the right to object to the processing of his or her personal data, including processing for direct marketing, automated processing, or profiling. It requires that the consent of the data subject be secured in the collecting and processing of her data. So you you can exercise your right to object if the personal data processing involved is based on consent or legitimate interest. When you object or withhold your consent, the PIC or the Personal Information Controller should no longer process the personal data unless the processing is pursuant to a subpoena for obvious purposes or a result of a legal obligation. In case there is any change or amendment to the information previously given to you, you should be notified and given an opportunity to withhold consent. The third one is the right to access. Reasonable access to, upon demand, the following: contents of his or her personal information that were processed, sources from which personal information were obtained, names and addresses of recipients of the personal information, manner by which such data were processed, reasons for the disclosure of the personal information to recipients, information on automated process where the data will or likely to be made as the sole basis for any decision significantly affecting or will affect the data subject. Date when his or her personal information concerning the data subject were last accessed and modified. And the last is the designation or name or identity and address of the personal information controller. So the right to access, this is your right to find out whether an organization holds any personal data about you, and if so, gain reasonable access to them. Through this right, you may also ask them to provide you with a written description of the kind of information they have about you, as well as their purposes for holding them. Under the Data Privacy Act of 2012, you have a right to obtain from an organization a copy of any information relating to you that they have on their computer database and or in manual filing system. It should be provided in an easy-to-access format, accompanied with a full explanation executed in plain language. Next is the right to erasure or blocking. Suspend, withdraw, or order the blocking, removal, or destruction of his or her personal information from the Personal Information Controller's filing system upon discovery and substantial proof that the personal information are incomplete, outdated, false, unlawfully obtained, used for unauthorized purposes, or are no longer necessary for the purposes for which they were collected. Under the law, you have the right to suspend, withdraw, or order the blocking, removal, or destruction of your personal data. You can exercise this right upon discovery and substantial proof of the following: your personal data is incomplete, outdated, false, or unlawfully obtained. It is being used for purposes you did not authorize. The data is no longer necessary for the purposes for which they were collected. You decided to withdraw consent, or you object to its processing and there is no overriding legal ground for its processing. The data concerns information prejudicial to the data subject unless justified by freedom of speech or expression or of the press or otherwise authorized like by the court of law. The processing is unlawful. The Personal Information Controller or the Personal Information Processor violated your rights as data subject. So by this following, if you found out this substantial proof, you have the right to block your information. So how to exercise your right to erasure or blocking? Execute a written request to the organization addressed to its data protection officer or the DPO and have it received, and the letter mention that your request is being made in exercise of your right to erasure under the Data Privacy Act of 2012. Documents to support your request must be attached. The DPO must act on your written request. In case you feel your request have not been addressed satisfactorily, you may file a formal complaint before the NPC attached therewith your request letter to the DPO. Next is the right to rectify. Dispute the inaccuracy or error in the personal information and have the Personal Information Controller correct it immediately and accordingly unless the request is vexatious or otherwise unreasonable. You have the right to dispute and have corrected any inaccuracy or error in the data a Personal Information Controller hold about you. The PIC should act on it immediately and accordingly unless the request is vexatious or unreasonable. Once corrected, the PIC should ensure that your access and receipt of both new and retracted information. PICs should also furnish third parties with said information should you request. The right to damages. Be indemnified for any damages sustained due to such inaccurate, incomplete, outdated, false, unlawfully obtained, or unauthorized use of personal information. So, how to exercise your right to damages? Write or speak to the organization which mishandled your personal information to see if you can reach an agreement and claim compensation. If you feel that your concern has not been satisfactorily addressed, you should write to the organization and inform them of your intent to take the matter to the court. Before you start court proceedings, talk to a legal advisor if you want to make a claim in court. The NPC has no role in dealing with compensation claims, but you may request as to access if the organization mishandled your personal data and broke the DPA. You can give a copy of the NPC's letter to the court along with the evidence to prove your claim. This, however, does not guarantee that the judge will fully agree with NPC's view. You may also require someone from the NPC to give expert evidence, which will only be allowed if the judge orders it the party calling the witness will have to shoulder the corresponding cost. Section 17. Transmissibility of rights of the data subject. The lawful heirs and assigns of the data subject may invoke the right of the data subject for which he or she is an heir or assignee at any time after the death of the data subject or when the data subject is incapacitated or incapable of exercising the right as enumerated in the immediately preceding section. So, just like any physical property such as real estate, you can assign your rights as a data subject to your legal assignee or lawful heir. Similarly, you may assert another person's right as a data subject, provided he or she authorizes you as a legal assignee. You may also invoke another person's data privacy rights after his or her death if you are his or her legal heir. The same principle applies to parents of minors or their legal guardian who are responsible for asserting their rights on their behalf. This right, however, is not applicable in case the process personal data being contested are used only for scientific and statistical research. The practical need for transmissibility. An individual's personal data lives on even after his death. As such, they could still be subject to privacy violations, whether intentional or otherwise. The Data Privacy Act of 2012 included this provision to protect their privacy right through living person willing to assume the responsibility on their behalf. The transmissibility of data privacy rights has been extended to living adults who are unable to protect their own rights and wish to assign the responsibility to someone else. Section 18. Right to data portability. The data subject shall have the right, where personal information is processed by electronic means and in a structured and commonly used format, to obtain from the personal information controller a copy of data undergoing processing in an electronic or structured format, which is commonly used and allows for further use by the data subject. This right assures that you remain in full control of your data. Data portability allows you to obtain and electronically move, copy, or transfer your data in a secure manner for further use. It enables the free flow of your personal information across the internet and organizations according to your preference. This is important, especially now that several organizations and services can reuse the same data. Data portability allows you to manage your personal data in your private device and to transmit your data from one personal information controller to another. As such, it promotes competition that fosters, better services for the public. For example, in case you want to close your Facebook account and leave the service, or simply feel like you've shared a lot of information about your life and want a backup of all your Facebook data, you may exercise your right to data portability. You may also exercise this right if you intend to get usable copy of your personal health records for the use of other doctors you may like to consult. In banking, the right to data portability may be used to reduce the risk of being locked in with one single service provider, thereby expanding customers' options and improving customer services. So how to exercise your right to data portability? Various online platforms have been making data portability an available and instant option for its users. For instance, Facebook enabled its users to readily download all their personal content and information, including wall posts, status updates, photos, videos, and conversation threads. Currently, users will just have to click at the top right of any Facebook page and select Settings, then click Download a copy of your Facebook data at the bottom of General Account Settings and click Start My Archive. Google has a similar feature that readily allows its users to create an archive to keep for their personal record or for use in another services. Next is the Section 19, Non-Applicability. The immediately preceding sections are not applicable if the processed personal information are used only for the needs of scientific and statistical research, and on the basis of such, no activities are carried out and no decisions are taken regarding the data subject. So those preceding sections are not applicable if the processed personal information are used just for scientific and statistical research, like getting the numbers of family in each province or medical study that involves the personal information of an individual. These are not applicable because personal information should be held under strict confidentiality and shall be used only for the declared purpose. Likewise, the immediately preceding sections are not applicable to processing of personal information gathered for the purpose of investigations in relation to any criminal, administrative, or tax liabilities of a data subject. So let's proceed to the Chapter 5 of the Data Privacy Act of 2012, the Security of Personal Information. Section 20, Security of Personal Information. Letter A. The Personal Information Controller must implement reasonable and appropriate organizational, physical, and technical measures intended for the protection of personal information against any accidental or unlawful destruction, alteration, and disclosure, as well as against any other unlawful processing. So the PIC or Personal Information Controller must implement a sensible and appropriate organizational like data protection, information security policies and procedures, physical and technical measures like encryption, that intended for the security or protection of the personal information against any accidental or unlawful destruction, alteration, and disclosure like unauthorized release of information. Letter B. The Personal Information Controller shall implement reasonable and appropriate measures to protect personal information against natural dangers such as accidental loss or destruction, and human dangers such as unlawful access, fraudulent misuse, unlawful destruction, alteration, and contamination. So we have two types of dangers: natural dangers like accidental loss or destruction caused by disasters like floods, tsunamis, and other disasters that may cause great damage on environment, property, and human life. We also have human dangers like unlawful access, accessing the sensitive data without permission, unlawful destruction, and alteration or changing the important information. Letter C. The determination of the appropriate level of security under this section must take into account the nature of the personal information to be protected, the risk represented by the processing, the size of the organization and complexity of its operations, current data privacy best practice, and the cost of security implementation. So the subject to guidelines as the Commission may issue from time to time, the measures implemented must include the safeguards to protect its computer network against accidental, unlawful, or unauthorized usage or interference with or hindering of their functioning or availability. A process for identifying and accessing reasonably foreseeable vulnerabilities in its computer networks and for taking preventive, corrective, and mitigating action against security incidents that can lead to a security breach. Letter D. The Personal Information Controller must further ensure that third parties processing personal information on its behalf shall implement the security measures required by the provision. Third parties here are those individuals who are assigned to be as a hearer or proxy of the data subject. They should also implement the security measures required by the said provision. Letter E. The employees, agents, or representatives of a personal information controller who are involved in the processing of personal information shall operate and hold personal information under strict confidentiality if the personal information are not intended for public disclosure. So of course, personal information is for confidentiality. The employees, agents, or representatives who process the personal information must operate and hold those personal information under strict confidentiality. If it is not intended for public disclosure, they must hold it confidentially. Letter F. The personal information controller shall promptly notify the Commission and affected data subjects when sensitive personal information or other information that may, under the circumstances, be used to enable identify fraud are reasonably believed to have been acquired by an authorized person, and the personal information controller or the Commission believes that such an authorized acquisition is likely to give rise to a real risk of serious harm to any affected data subject. So, the notification shall at least describe the nature of the breach, the personal information possibly involved, and the measures taken by the entity to address the breach. Notification may be delayed only to the extent necessary to determine the scope of the breach, to prevent further disclosures, or to restore reasonably integrity to the information and communication system. The Commission may exempt a personal information controller from notification where, in its reasonable judgment, such notification would not be in the public interest or in the interest of the affected data subject. The Commission may authorize postponement of notification where it may hinder the progress of a criminal investigation related to a serious breach. In evaluating if notification is unwarranted, the Commission may take into account compliance by the personal information controller with this section and existence of good faith in the acquisition of personal information. So that would be all my part. Thank you for listening.